May it please the Court, Elizabeth Caddick for Chevall Johnson. The touchstone of the Fourth Amendment is reasonableness. If a seizure of personal property or effects, which is an automobile, is unreasonable, then the Fourth Amendment has been violated. The only purpose of an impoundment of an automobile after the driver has been arrested is for community caretaking purposes, meaning the car is illegally parked, interfering with the flow of traffic, is a hazard to the public, or perhaps would be subject to vandalism if it's in a high crime area or an area that's been known for vandalism of cars. In this case, Mr. Johnson stopped and parked and locked his car on his street a couple of doors down from his home. The police nonetheless impounded his car and searched it. That was a violation of the Fourth Amendment and the Massachusetts Constitution, and therefore the evidence seized from it, the loaded handgun, should be suppressed. There are a number of federal cases that concern the suppression of evidence when a car has been impounded when in fact there's no evidence that there's a violation, that there's a community caretaking.
What's the difference between the facts in this case and the case that we just had from Springfield? I can't remember the name of the case.
Eddington.
Yeah.
Eddington. Oh,
yeah,
Eddington.
I wrote it, but I can't.
Okay. Well, in Eddington, no one was the owner of the car. Even the driver wasn't the owner of the car, and there was no evidence that it was lawfully parked near, the owner's home, because there was no owner. There was no one who could drive it. Apparently none of the passengers could drive it. The driver couldn't drive it. In this case, they knew Chevall Johnson owned the car. They knew where he lived. Two things confirmed where he lived. The officer checked when he was following the car, checked the RMV and saw that he lived on St. William Street. And then when he stopped Chevall Johnson, he looked at the driver's license. It said he lived at St. William Street. And Johnson pointed out his home. He says, well, I live right there. So we knew in this case that the car was lawfully parked. And the car certainly would suffer no greater risk of vandalism than it would have suffered if Johnson had just...
Are you concerned so much about it being towed or about it being searched?
Impounded. Well, what was improper was the impoundment in the first place.
Well, as I understand the Commonwealth's position, at least in part on this, they are maintaining that they had the right to go into the car because they could see in plain view a half-empty liquor bottle, and that once they opened up the car, they were then subject to a kind of liability for anything missing, and therefore had to impound it at this point. So there seems to me like a somewhat separate question about whether they could have, done the search then and then locked up the car and left it there, versus towing it. And it doesn't seem to me that you're as fixed on the towing part as you are the impounding part.
Well, right. Well, that's one of
because they could have left it there, but I mean that's
right.
not the significant difference. The search happened that
right.
you're concerned with on site, right?
Right, and any exception to the warrant requirement is not met here. One exception would be seizing evidence of a crime, which would be the open bottle.
Why isn't that perfectly on point? How could that not be relevant to an investigation into whether or not he was operating under the influence of alcohol? A half bottle, open alcohol, right there in plain view in the car.
Well, when you're charged with operating under the influence of alcohol, it all has to do with your blood alcohol level, and so there's no evidence of someone's blood alcohol level when they search the car.
But it doesn't have to do with blood alcohol always. Impairment. You can be driving impaired. You don't have to take a breathalyzer test. And whether or not someone has got alcohol literally on the seat next to them, a half-open bottle, seems to be very relevant, just like beer cans on the floor of a car, as to whether they were impaired by alcohol.
Well, they saw that he ran a red light.
He ran a red light. That's evidence of some
Right.
kind of negligence.
And he reeked of alcohol. His speech was slurred. He was agitated. He was unsteady on his feet.
You're making my case.
Well, they already knew. Well, but the argument isn't that he shouldn't have been charged with driving under the influence, which in fact he wasn't charged with.
No, he wasn't, because he committed other crimes and
Right.
they found more serious
Right.
evidence of a more serious crime. So,
Right.
but that was certainly one of the concerns the officers had on site.
Right. But finding an open bottle of alcohol is not evidence that he drove under the influence. Driving
In the
impaired
car,
is evidence.
That is a very fine line. It's certainly relevant. It would be admissible at trial, wouldn't it?
It comes into evidence all the time in OUI cases.
Right. Well, if the
In fact,
justification...
isn't it a crime to have an open container
Yes.
of alcohol in a car?
Right, and if-
That's directly evidence of a crime.
Right. And if they were to seize that evidence, then the search has to be over, and there's a case...
Yeah, no, they opened the
Yeah.
door, there's the gun. I think isn't that they opened the door and the gun was right there?
But they were searching the car. They weren't... If they were simply opening the car to get the...
Close
bottle-
my eyes, reach in, find the alcohol
Well,
bottle,
they're-
open the door and see the gun right on the holder?
They're not... first of all, we don't know that. That wasn't the justification by the Commonwealth at the hearing, and so certainly that wasn't scrutinized at the suppression hearing. If they were going to seize the open bottle of alcohol for the charge, as evidence of the crime of driving with an open bottle of alcohol.
Or driving under the influence of
All right,
alcohol.
and they seized it, fine, either way, and they seized it. The search has to end unless there's any probable cause to believe there's further evidence in the car of the crime.
I would agree with you that wouldn't justify opening up briefcases in the back and popping the trunk and all of that, but I thought the gun was in plain view when you opened the door.
Well,
Wasn't it in the pocket of the door?
It was in the pocket of the door, and if it had been on, say, the console, in plain view.
But the testimony was that the officer opened the door and yelled gun. So, I mean, the sequence was open door, yell gun. It's not, they're not on this record anyway. Was there anything further?
Right, but he was searching the car. He was doing a thorough search of the car in this particular set of facts. And so the fact that he would look down into the mat pocket is because he was searching the car. If all he was doing was going to seize what was on the dashboard, it was right on the dashboard, and he just opened it, seized it, and closed the door, there's no evidence that he would have looked down into the map pocket of the door.
Does the motivation of the officer matter? I mean, if Justice Duffley is correct that he opened the door and yelled gun, the fact that he was intending just to seize the bottle or that he was intending to do an inventory search,
Right.
at the end of the day, does it matter?
No, if that were the facts of the case, then we wouldn't be here. If it was inadvertent, if all he was doing was going to seize the bottle and he inadvertently saw the gun in the map pocket, then certainly it shouldn't have been suppressed.
Could you help me? I thought I read that at one point the defendant said to the police, "I don't care, search, whatever." Did he do that?
He did when they already told him they were going to search the car, and they already told him he was going to be arrested, and he was already surrounded by the 5 officers and wasn't free to leave. So the argument is that the consent to search is invalid because it was a mere acquiescence to a show of authority. And so it was already a fait accompli, they were going to search, and so he's like, okay, fine, whatever, and they took the keys from his hand.
The judge didn't decide it on that basis in any event, which it might have been a factual question whether it was voluntary or not.
Right. I was just going through how they couldn't justify it under any other exception.
If I could turn your attention to your Second Amendment claim, what is your Second Amendment claim as to the presumption which we apply under the statute with regard to the possession of a firearm?
Well, the argument is that now that the possession of a firearm is a constitutional right, presuming, as the state does now, that possessing a gun is unlawful, and then therefore the defendant has to show that he has a right to possess it by proving that he has a license is unconstitutional. There's a presumption that someone exercising their constitutional right is committing a crime. And that all of the reasoning of this court before Heller is now, has to be overturned.
So you would say, I take it, because Powell obviously came after Heller and McDonald and kind of addressed this question about where the burden was, right? It's just wrong, is that?
Right, and you know, Powell.
I don't mean, I'm not trying to put you on the spot,
No,
but I mean,
no.
but that's your point,
Right.
is that it really, that isn't accurate in your view of where the Constitution requires us to be.
Right, right.
So there's no need for anyone to apply for a license?
Well, no, I'm not saying that, because even the Supreme Court said that there might be legitimate licensing. But if not having a license then has to be an element of the crime that the Commonwealth has to prove. And it wouldn't be burdensome at all to prove, especially nowadays with you know, computer systems and stuff. It's not difficult to show that someone is licensed. And
Is there a central licensing? How would that be done?
Oh, I don't know if there's a central licensing system, but I also don't think that would be difficult. Cars, you know, driver's licenses, hunting licenses, there's
Aren't licensing, isn't that done by local police chiefs?
Yes, but that doesn't mean, well, but the local police departments are part of a larger system, the Corey system and the FBI criminal system, the fingerprint system. So local police are full of state and national internet systems anyway, and there's no reason that they can't also be part of, or have the licensing be part of the national system also.
But is it?
Well, not that I know of.
And would the Commonwealth also have to prove the absence of any exemption under the law? There are various exemptions with regard to the license to carry. Would that be the Commonwealth's burden under your?
Well, yeah, sure,
vision?
because it still is. For example, if Johnson had been charged with possession of a firearm by a felon, the Commonwealth would have to prove that he had been convicted of a felony. So that would still remain the same, that there's no...
Right, but it's a lot easier to prove that somebody is a felon than to prove the absence of a license, especially if it's done by local authorities, and especially if there's some delay. Even if there is a central repository, you'd have to then show that it's not in the queue of things to be inputted into that central repository. Aren't we entitled, in view of the complexity involved, to impose that burden?
Not when you're talking about a constitutional right,
But
no.
it's a burden of production, not a burden of proof.
Well, but the problem is it's a presumption of unlawfulness. That's the problem, the presumption that someone lawfully exercising their Second Amendment right is nonetheless committing a crime, and they then have to prove they're not. So it might be a burden on the state to have to do that, but after Heller and McDonald, that's the way it has to be in order for there to be a constitutional conviction.
Is it a Second Amendment right you're arguing, or really a due process right? That is, if it's an element of the crime to be unlicensed, which it is, or maybe it is, you would argue that it is, therefore you can't put the burden on the defendant to prove that. I mean, it could be any crime, but you can't put the burden on the defendant to prove an element of the crime that the Commonwealth has to prove. I mean, isn't that really a due process issue?
Well, but because it's not an element of the crime, that's really not the argument. The argument is that it's a Second Amendment issue. And the Second Amendment issue is simply that the burden is now on, that the presumption is that he's exercising a constitutional right unlawfully. So it is a Second Amendment as opposed to a due process argument.
Well, if the Commonwealth could establish that this was a narrowly tailored way of approaching a constitutional licensing scheme, I mean, it seems to me that they could justify that, couldn't they? At least the burden of production?
When the courts evaluate, if you look at the standard of review for lawfulness of these Second Amendment cases, they use the First Amendment standard of review. And so if you're asking the defendant to do that, it's like asking someone to have the burden of showing that they're properly exercising their First Amendment right, and people don't have the burden to show that they're properly exercising their right.
But you don't have to have a license to exercise your First Amendment right, and I think you would concede that the Commonwealth can require people who carry guns in public to have some sort of license to do so.
Right, but people aren't presumed to unlawfully exercise their First Amendment rights, because the focus is on the...
Because you can't license First Amendment speech,
Well,
but you can license the possession of firearms.
Well, I think you can license First Amendment speech. If someone has to have a license in order to do a march downtown, then there's, yeah, so I think the problem is just the presumption that someone possessing a gun is doing so unlawfully, and that they have to then prove that they can do so.
All right, thank you, Counsel.
Thank you.
Good morning, Your Honors. May it please the Court. Janice Noble on behalf of the Commonwealth. Turning first to the defendant's search and seizure issue. The recovery of the defendant's gun from the vehicle was proper under the Fourth Amendment and Article 14 because the officers had probable cause to seize that open bottle of cognac that was on the defendant's dashboard. Once they did that, those officers were in lawful control of the vehicle and would have had to inventory that car under the Boston Police Department's inventory policy.
How is that?
That doesn't follow, does it? I mean, just because you search a car and you find some evidence of a crime doesn't mean that you've got to tow it, which is why you would inventory it.
Not necessarily, Your Honor. Under the Boston Police Department's inventory policy, there are a number of reasons requiring an inventory search, not just the tow. One of them is a tow. Whenever an officer has lawful control of a vehicle, and that can mean making sure that it is locked, making sure that the windows are closed,
and you think that's constitutional?
It has been held constitutional by this court.
Part of it?
Yeah, yes, Your Honor, I do believe so. This court has looked at the Boston Police Department's written inventory policy in Ellerbein and in cases of that nature. The only requirement under Article 14 is that the inventory policy be in writing. The inventory policy here was entered in evidence during the motion to suppress. It's reproduced at pages 20 through 22, I believe, in the defendant's appendix.
So
and
if there is any reason, so if you arrest someone in front of their home and you open the car door for any reason, this is the police officer, opens the car door for any reason or takes the keys for any reason, then the car is under the control of the police and they have the right to essentially inventory it, which means search everything?
Yes, Your Honor, that is the case because part of the inventory policy is not just to protect against vandalism, it is also to protect against false claims.
Yes, but it has to be balanced against some right to reasonable privacy and security. I mean, it can't be, seems to me, that anytime the police close a door on a car, they somehow have control and can then search everywhere.
I think, Your Honor, the inventory policy is very clear and has been upheld in numerous instances because the police...
In this fashion, on this very point... that
Not towing it.
I'm sorry, Your Honor?
I mean, just this, not for towing.
Not for towing purposes, but the inventory policy doesn't just cover towing. It covers... And it's, like, again, points 2 and 3, I believe, in the inventory policy.
Right. The question is not what it says. The question is whether or not it is constitutional to justify an inventory search when the police do not tow the vehicle to their lot, but simply leave it on the street and ensure that it's locked.
It is constitutional.
And are you saying, have we ever addressed that particular issue?
I don't believe this court has. I believe this court has looked at it in the view of a tow situation, which did, in fact, happen here. This car was towed for a number of different reasons.
But it was searched first.
Yes, the inventory policy.
So the tow is a secondary consideration, and that's clearly defense counsel's position, too, it seems. The problem, I think, that's being raised is that there was an inventory search done on the basis, or I think that you're justifying it on the basis that the inventory policy says that once the police have control over the car, in this case, once they went in to get the half-empty bottle of alcohol, then they were possibly then liable against charges of false claims, and so they had the right then, or they had the obligation then under the inventory policy. That's when the search took place.
That's correct, Your Honor, but that's not the only reason why this search was justified. The search was also justified because the police had probable cause to suspect that the defendant had been committing the crime of operating under the influence of alcohol. They were entitled, after seeing that bottle of cognac on the dashboard, to search for additional evidence of that crime. It could have been a glass that that the defendant had been drinking out of. They were certainly able to get into the car to look for additional evidence. But in any event, and I believe it was Justice Duffley that mentioned this earlier on in my sister's argument, when the officers went in to get that bottle of cognac, or whatever their subjective intent was, and I believe we had discussed that earlier, as soon as he opens the door, it's gun. An officer is not required under the Fourth Amendment or Article 14 to ignore things that he or she sees. As soon as he opens the door, the testimony at the motion to suppress is gun. At that point, the officers, of course, could seize that gun. There was no problem, either if you look at it through the probable cause analysis lens or through the lens of the inventory policy, that this was not a proper search under Article 14 and under the Fourth Amendment to the United States Constitution.
Before you get to the Second Amendment question, let me ask you, explain, why was the car towed? It was parked just a couple of houses down from his house in a legal parking spot.
There were two reasons why it was towed, I believe, Your Honor. Number one, after the defendant's license had been suspended.
His driver's license.
His driver's license had been suspended. He was the only authorized user that the officers saw.
In front of his house.
I think the tow, when somebody's license is suspended, I think Eddington somewhat discusses this in being in a lawful parking spot and still being able to tow the vehicle, although the facts of Eddington, I do agree, are different. There's no testimony here that we were in a high-crime neighborhood, but there was no one else who had control of the vehicle and could actually take it, and I think that's the reason for the tow.
Why would you have needed somebody to have control of a car that's lawfully parked near the man's house, which they knew it was, since they had the driver's license?
At the time, initially, I don't think they were aware because he had been lying to them. He had been giving false names.
By the time they made up the decision to tow the car, though, they knew.
I think the officer's testimony was that he had decided to tow the car even prior to that because of the suspended license. It's also, Boston streets. It's possible that there was a resident parking situation. It's possible that there was street cleaning.
But he was a resident.
He may not have had a sticker. I know, certainly. No
evidence of that.
There is no evidence of that, but what we're talking about is whether or not this officer was acting reasonably, which is the touchstone of Article 14 of the Fourth Amendment. And towing the car was a reasonable alternative, but this Court's decision in this case does not rise and fall on the ultimate decision to tow this car. It rises and falls on whether or not the recovery of that gun was proper, and the Commonwealth asserts that it was.
If I can turn you to the issue of the duplicative or the allegedly duplicative convictions for possession of a loaded firearm, possession of ammunition.
Certainly, Your Honor.
Is it your view that the possession of each bullet is a separate crime?
I believe it can be, yes, Your Honor.
So if you find 30 bullets, then you can charge them with 30 counts of possession of ammunition?
Yes, Your Honor, you can. Each individual projectile or ammunition, as defined under the law, can be considered a separate count of possession of ammunition. I think for...
Ever heard that being done?
No, I have not, and I think realistically and practically speaking, it would be quite burdensome on the courts to be charging a defendant with 40 separate counts of possession of ammunition. But that being said, the law still allows it. And the possession, it is legally permissible, and I think this is the crux of the Commonwealth's point here. It is legally permissible for a defendant to be convicted of possession of ammunition and possession of a loaded firearm when all of the projectiles are contained within the same gun.
Because of what you just said? Because you could convict on each... So the jury's supposed to say, oh, that one is for the gun and that one is for something? I mean...
As long as the yes, Your Honor, as long as the testimony supports that, yes. And here, Officer Rose testified that there was one spent shell casing in the... It was a revolver, so we have a spent shell casing in the revolver, and we have 3 live rounds of ammunition in the chamber.
So if a defendant steals a pair of... If somebody's charged with stealing a pair of shoes with laces in them, you can charge them with a separate count for each shoe and a separate count for each set of laces.
Well, I think that's a bit factually distinguishable, and I'd say that because I think shoes actually come in pairs. Ammunition, it only takes one bullet to make up the charge of possession of ammunition.
Well, but likewise, it's used the same word if there were 100 bullets.
I think there could, but that doesn't mean, but each one of those bullets, I'm sorry, Your Honor.
Well, I mean, you're making an assumption that the intention was that instead of saying each bullet, that's what the legislature intended. But it doesn't say that.
No, I believe what the legislature said is possession of ammunition. This Commonwealth has charged, and I'm sure this court has heard cases, I can't think of any off the top of my head, where somebody is convicted and appeals a conviction for possession of one bullet, and that is possession of ammunition.
Because the singular is encompassed within the plural in that case.
I'm sorry?
The singular is encompassed within the plural in that case.
Sure, I understand. I think I understand Your Honor's point, but I don't, the Commonwealth can choose, that shell casing is also ammunition under the statute. This definition of ammunition includes a casing. That can be possession. That could be the loaded firearm. That could be the possession of ammunition. It may come down to the way the case is argued. It may come down to the way testimony comes in at trial. But it does, the legislature has authorized, and it is legally permissible, to have ammunition and loaded firearm contained within the same firearm or within the same gun.
Can I ask you, turning to the Second Amendment
Certainly, Your Honor.
Briefly, do you agree that there's a presumption under Massachusetts law that the possession of a firearm is illegal?
Yes, I do.
And
Well,
do
let me retract that. Let me take a step back. I think I may have answered that a little bit too quickly, Your Honor. I believe that there is a presumption that you must be licensed to carry a firearm. There is not I think the Second Amendment, I think Heller and McDonald made clear that there is a right to possess a firearm in the home. In terms of carrying a firearm outside of the home, the presumption in the Commonwealth, which has been reinforced by this court most recently in Wallace and prior to that in Powell, indicates that a person, there is no problem with requiring a license. And when a defendant does not take that step to challenge a licensing scheme through the proper channels, they cannot raise a Second Amendment claim here in this type of a context.
But we said in Couture, and I quote, "A police officer's knowledge that an individual is carrying a handgun in and of itself does not furnish probable cause to believe that the individual is illegally carrying that gun." So if you cannot, on that basis alone, arrest somebody, how is that consistent with the Second Amendment?
I think the officer can then say, are you licensed to carry this firearm?
Right.
And if that defendant says no, then there is certainly probable cause to arrest.
I guess that's my point. In Couture, we said it would not be appropriate to arrest until you had information, but when that same person goes to trial, we say it's appropriate to convict.
In the absence of that information.
In the absence of that information. So how can it be appropriate how can it not be appropriate to arrest, but be appropriate to convict? Because
proof of a license is not an element of the crime. And this court stated that clearly in Commonwealth versus Jones, at 327 at 406, I believe is the pin site. In this court held, and I believe this is a direct quote coming out of the Powell case, we explain that the absence of a license is not an element of the crime as the phrase is commonly used.
And is that going to be consistent with the U.S. Supreme Court's interpretation of the Second Amendment?
Yes, I believe it is, because even under the Supreme Court's interpretation in Heller and McDonald, there are certain categories of people in certain situations where it will not be proper to carry a firearm. The court mentioned juveniles, the court mentioned felons. In order to prevent those categories of people or those categories of individuals from being able to carry a firearm, there needs to be some type of a licensing scheme. The officers aren't just going to be able, and I think the court was touching on this, to say, look at this person and say, do you have, be able to check randomly, do you have a license? It's not unreasonable for an officer to be able to ask that question, and it's not unreasonable to require the defendant to have that burden of production, not burden of proof, because this is not an element of the crime.
Well, I mean, certainly you would agree that if it were not a defense that the person had a license, it would be unconstitutional to say that the mere possession, put aside the carrying, the mere possession of a firearm in the home cannot be a crime.
I think under Heller and McDonald, I think that is clear, that the mere possession in the home is not presumptively a crime. But we're not dealing with that situation. We are dealing with the situation wherein there is carrying outside the home where licensing schemes are proper, even in the wake of Heller, in the wake of McDonald, and this court has consistently, or I shouldn't say consistently, over the last couple of recent cases following the Supreme Court's decisions, have affirmed that. And this court, most recently in Powell at Note 10, talked about the licensing scheme, saying that it is proper for the Commonwealth to require, or for a defendant to produce that license if, in fact, he wants to assert that defense at trial. Excuse me, Your Honor.
And is it also your position that we should not interpret Heller to include carrying on the street, but only carrying within the home?
Yes, correct. That is our position, that it should only require in the home, because that's what those two cases have interpreted. And I believe that a Supreme Court decision just came out last week where it was where the Supreme Court declined cert on a case where there was where it was carrying outside the home, where they declined to review that particular issue. So they do seem to be sticking with the Second Amendment in the home. And I think it is also important to note that the plaintiffs in Heller and in McDonald did challenge the licensing scheme, as opposed to trying to raise a Second Amendment claim in this type of a context.
They declined cert on about 98% of their cases. Are we to give meaning to a declination of certiorari?
I think you can in this particular case, where the court had just recently taken both Heller and McDonald and seemed to be very interested in this issue of Second Amendment rights. I think that is a statement. I certainly don't want to even pretend to be in the minds of the justices in Washington, D.C., but I think it is telling that when presented with a situation where they could review possession or carrying outside of the home, they decided not to do that. If the court has no further questions, I'll rest on the brief.
Thank you.
Thank you.